Thank you. And I appreciate all the information you put forth. I just wanted to point out, because you made reference to the statement that our courts are overcrowded, which I'm sure they are. It is the case that in the Bronx, and I'm sure it's true in the other boroughs in the city and probably throughout the state, the number of judges that the Constitution allows to be elected is in excess of the number of judges that we actually have, meaning that each of our boroughs is entitled to a significant increase in the number of judges. And if that were ever done, I'm sure with the leadership of our governor, and money put in the budget for it, that would certainly help the courts in general and would certainly mean that more people could have access to justice in our courts.
Absolutely. We definitely agree with that. I'm a litigator. I go into the Bronx Civil Court regularly, and the number of cases that I'm able to get through in a quickly is pretty much non-existent. It takes a while to get cases to go before a judge, and we would welcome opportunities for more judges to be on hand to provide some relief to consumers in a faster way.
Okay. Question, anyone? Okay, thank you very much.
Thank you again.
A. Michael Weber. Swear your testimony will be the truth.
I do. Thank you for the opportunity. I'm an employment lawyer. Our firm represents employers. The prior testimony has been seeming one-sided on consumer, and that's why I've asked to talk. Labor arbitration has been around a long time. It's been the preferred mechanism to resolve labor disputes in the workplace for over 50 years. Employment contracts are now following that trend, where employers found that the history of resolving labor disputes primarily with unions and employees have been a preferred manner of resolving disputes, and I think that continues today in employment disputes. If you look at the rules that JAMS and AAA provide, and you've heard talk about it, each are about 40 to 50 pages long, and they have a due process protocol. JAMS and AA will not hear a dispute unless an employee has the same rights he or she would have in court, same statutory rights, same ability to recover any form of damages that employee could recover in a court of law. Do I think arbitration is always faster and cheaper? Generally it is, but there are exceptions. I would acknowledge that. Do all employers pursue arbitration in their employment context? No, not all do. But the vast majority think it's a preferred measure and method to get disputes resolved quickly and privately. And I want to emphasize the privacy aspect and the confidentiality. Some of these employment disputes, as this panel well knows, can be very messy and complicated and involve allegations that would be best not brought in a public court of law. And I think that is a benefit to many of the arbitrations that we've handled and that exist today. My sense is that, contrary to some of the testimony you've heard, employment arbitrators' decisions are well known within the community. And I say community, I mean both the plaintiff's bar and the defense bar. Arbitrators are selected mutually. And plaintiff's bar know very well the arbitrators that have a reputation of rendering fair decisions, both on behalf of employees and employers. And I think those that continue to get selected are those that do, in fact, render fair decisions. And employers do not win every case. Believe me, I know the statistics. But I think those arbitrators that are well known to both plaintiffs and defendants' bars are those that will render fair decisions. It's been true in traditional labor arbitration forever, for over 50 or 60 years. I think it exists today, and I think that it will continue to exist. So I think that, in contrast to some of the consumer issues that I will not and cannot speak about, I think employment and labor arbitration is quite different. It's quite transparent. It's absolutely as balanced as a proceeding in court. I think it's quicker, and it's much more beneficial, I think, in the workplace, generally for the employee and the employer. And those are my brief comments. I wanted to keep them short and answer any questions the panel might have.
Not to ask a question particularly, but I did want to, you mentioned that the number of people testifying seemed to be pro-consumer. I just wanted, for the record, to indicate that we, in fact, invited a wide range of groups, and unfortunately, none of the hospital or health association organizations or actually bar associations accepted the invitation to testify. So we have the group that accepted, and we're very happy that you did. Just in terms of what you say, when employees, you paint a picture that is you say, mutually beneficial to both employers and employees. If that is the case, are employees given the choice of being able to not participate in participate in arbitration, to choose to, or is it mandatory? Do they have to assent to the arbitration, or it's mandatory?
Let me answer that, and also thank you, and let me expand on it. Typically in an employment application or an employment handbook, there is a provision that provides for arbitration. And it's not in fine print. It's actually in the same bold print that you'd find in an employee handbook, and it's often in a standalone separate document. The employee can choose not to go to work at the company and not be bound by the agreement. That's an option. Or can sign the agreement and go to work for the company. I think that is an option that the employee has where a consumer might not have.
Well, saying that, do you have any statistics, or could you point us in any place where there are contracts that are not mandatory arbitration, to say that there's a choice?
Yes.
Many employees, in fact, there was discussion particularly about low-wage earners who have very little choice in their in where they can obtain employment.
Sure. Many provisions requiring mandatory arbitration have an opt-out clause. So you get your documents relating to your employment. You have your mandatory arbitration provision. You can opt out of it. There are many agreements that have that provision. So employees can take it home and say, I don't want to be bound by that provision. That exists. I've seen it many times. We've drafted many of those contracts.
How often does that happen?
I don't have that statistic. I do know it has happened. I think it's probably on the low end percentage-wise. I would agree with you, sir. But I know it is an option, and it has been taken advantage of by employees in the past. I know that to be a fact. I can't give you the statistics, but I tend to think you're probably right. It's probably on the lower end.
Thank you very much. Unfortunately, by way of disclosure, full disclosure, I have to tell you that I am a member of the association that is testifying next, the National Employment Lawyers Association. So I think we would start with a difference of opinion here, particularly in 30 years of practice of employment law in upstate New York, which, by the way, it's very difficult to find plaintiffs' employment lawyers anywhere in upstate New York. I have never encountered an agreement that gave an employee an opt-out clause. So I would certainly recommend you to give counsel to my adversaries so you might draw up such an agreement for them. I have never encountered it.
Well, some of your colleagues are some of my friends who I've come across the table many times, and they will tell you that we've certainly done that. And those that, as I say, many of my friends are part of your organization, can call me and I'll show that to them. But yes, that does exist.
Well, I suspect you may be talking, in the area of executive compensation, where there's an opportunity for real negotiation, it is a very different ball game than with average employees. I think to suggest that your average employee taking even a low-level managerial position or below has any choice in the terms or conditions of employment, particularly when an entire industry does it the same way, to suggest that they can meaningfully walk away from the agreement. They have a choice, They can not earn a livelihood, but I think it's not reasonable to say that there's meaningful choice in the area of employees below higher levels in an enterprise.
Well, I can agree to disagree on that one, but let me just add this. In October of last year, the California Assembly, and we often look to California for guidance, passed a similar law that you're considering today, and on October 11th, Governor Brown vetoed that. And California often is ahead of these issues on occasion. And I think Governor Brown's comments are worth reviewing as to the reason why he did so. And I would recommend that, and I can certainly provide those his letter to the committee, and possibly suggest following his thinking as well.
We had a governor that vetoed having a neutral in civil service Section 75 proceedings as well, where the employer actually can appoint the arbitrator without any input from the employee or the employee organization. We had that vetoed by a governor, and I think probably most of us in this room would agree that that was not particularly sensible. So I think that the area of meaningful choice here is important to look at as to whether that's realistic. And I would direct your attention to the area of covenants not to compete, which have become very prevalent, more so than under traditional New York law, where these things were rarely enforceable. And in the non-compete area, which could be subject to arbitration under such an agreement as you are talking about, one of the problems that you have is even if the non-compete is unenforceable as a matter of law, number one, arbitrator's not bound to follow the law. Number two, the cost to the employee in defending litigation instituted by an employer to enforce a non-compete that is unenforceable or will eventually be found unenforceable is absolutely prohibitive. No average employee can afford a lawyer to defend against such claims, whether such claims are brought in court or in arbitration, and certainly they could be subject to arbitration if there was a clause in the agreement. Wouldn't you agree with that?
I was just going to say, it wouldn't matter in those non-compete situations whether the employer was trying to enforce the non-compete in court or in arbitration, or in federal court or state court. That same is true. So I don't think the benefits of arbitration in the employment context cuts one way or the other with respect to non-competes. So I think
well, there's the issue that the arbitrator doesn't have to follow the law. The arbitrator can take a position, which a lot of labor arbitrators do, because they come out of the union management situation where I've got an agreement here. It says you agreed not to compete with us. I'm not getting into the questions of whether that's enforceable under New York law or not, and that is really depriving an employee of an opportunity to move freely in the labor market, and I think that's a very serious problem.
I think most arbitrators, as I said earlier, who are viewed very carefully by both plaintiffs and defense bar, follow the law for the very reason that that's what they are, I think they take the oath to do so, whether they're required to or not, they do. And I think the plaintiffs bar would be well aware of those that do not and wouldn't select them in the future. So yes, you are right, they're not bound by it, but I think generally speaking, in my experience, they do follow the law and they try to apply it properly and even-handedly.
Well, I would say that there are certainly some who do, but I don't know of any oath that they take where they promise to follow the law. That is something new to me.
I've always found in my experience, and certainly in pre-arbitration statements, the arbitrators ask for detailed legal authority for our respective positions. I think they follow it, has been my experience, both in mediation and in arbitration. Whether they're legally bound to, all I can tell you is I think my experience is they do follow it.
Well, a lot of the arbitrators also don't have specific legal training. We had an arbitrator recently in a case of mine who we actually got enjoined by a federal court from proceeding with the arbitration because the arbitration involved allegations that were violative of the Family and Medical Leave Act. That arbitrator had no background in law, didn't know anything about FMLA, and further was trying to bill my client $1,800 only for the mere fact of adjourning a case while she sought to have her rights reviewed in the federal district court.
Let me address that cost issue. Every agreement we draft has a provision that the employer pays for the arbitration costs, and that the employee pays no more than what he or she would pay if they were to file a civil action. And I think most courts would not enforce an arbitration agreement that didn't provide that. Are there exceptions? There are, but at typically a higher level employees, executive employers. But for most employees in the workplace, if there's an arbitration agreement, the employer pays the cost. The employer only pays the cost of what the filing fee would be in a civil proceeding.
Well, one thing I will say, and this is very true, I can speak a little bit to the situation in the 5 boroughs, but upstate, the courts are much more conservative, and getting courts to really review any arbitration agreement would be most difficult.
So it sounds like you'd be in favor of an arbitration upstate.
In honesty, I've had some situations where, in truth, the fact that arbitrators don't follow the law has worked to the benefit of the employee. But for the most part, I would say that the environment, here's where I would disagree. The environment that you talked about, where the precedent was set in the traditional labor management relationship where the union is an equal player with management, really don't apply at all to individual arbitrations. So by and large, if I'm handling any type of employment-related litigation, I would never prefer arbitration, except in the rare thing where I was basically just making an argument based on equity rather than law.
I think that the counterpart to and I don't disagree with you, where in the union context, you have the union on one side, the employer on the other. But what's happened today is you have a very robust plaintiff's bar. Plaintiffs' lawyers are very skillful and very knowledgeable and very well recognized by arbitrators, whether it's FINRA, AAA, JAMS. And they are well regarded and they're well respected, and I think they have almost an equal level as unions did and do in those contexts. So I don't think, contrary to what people are saying, in the employment context, I think it's a even playing field, and that's been my experience.
Well, I can certainly say it's very, very difficult to find a plaintiff's employment lawyer from Kingston to the Canadian border and west to Syracuse. I say good luck with that one.
Well, I know we have offices in Rochester and lawyers practicing throughout the state, and there seem to be plenty of plaintiffs' lawyers bringing actions against our clients, so I guess if you look, you can find them.
Okay, thank you.
Thank you.
Next is Michael Grenard. Good afternoon. Do you swear your testimony will be the truth?
I do. As Mr. Steck said, my name is Michael Grenert. I am a member of the National Employment Lawyers Association of New York. Our members are employment lawyers who represent employees in litigation. And I've submitted an outline of some testimony, and NELA does formally express its support for A108 and A8191, and has previously expressed its support for A4791, which, as was alluded to in some testimony earlier, sought to prohibit employers who do business with the state from using mandatory arbitration clauses, or rather, I should say, the state would be able to stop doing business with employers who had such clauses. And as stated earlier, we do agree that that would be outside the scope of FAA preemption. I would like to address some of the comments we just heard from the defense side of the table about there being an even playing field when it comes to arbitration. I think that while, yes, I as a claimant's lawyer do have some knowledge, and I personally have practiced a lot in arbitration in my career. I've done many of them at the AAA, at FINRA, and at JAMS. You have to step back and look at the structure. It's the companies that draft the employment contracts or the handbook provisions they are the ones who select the arbitration provider, be it the AAA or JAMS. Sometimes they provide an option, but usually they're choosing one or the other. And so there's in effect a competition for the business of the employers. And if many AAA arbitrators or many JAMS arbitrators are issuing big arbitration awards against companies, the company has the option of saying, well, we no longer want to use JAMS. They're too hard on us. We're going to go use someone else. The plaintiff's bar doesn't have any say in that whatsoever. So one of the areas I do think that is important that Assembly 108 and 8191 do seek to address are these sunshine type of provisions, disclosure type of provisions, to try to create a more even playing field. I think they could be taken even further, quite frankly. Let's start with the arbitrator selection process. One big problem we have is, take the AAA, for example. When we bring a case, they give us a list of, let's say, half a dozen arbitrators, and you can rank them in the order of your preference, or you can strike ones that you don't like. The problem is, unless you've happened to have had one of those arbitrators before and know something about them, most of the time, even though I've been doing this for 20 years, most of the time, the majority of them, you never heard of them before. And you get a one-page bio, you know very little about them, and you have no ability to research their past decisions because they're all in a black box. They're not public. At FINRA they are, but that's a bit of a different animal because it's regulated by the SEC. The bills before the Assembly do seek to require providers like the AAA and JAMS to publish some information about arbitrations and their decisions. I think that could be taken a step further and require the publication of the awards themselves. Partly for the reason I said, that it helps the parties to identify arbitrators who are exhibiting a bias in their pattern of decisions, and help them to select and weed out those arbitrators in the future, as well as for the reasons some of the prior witnesses testified about the effect of sunshine in general, that justice should be public, and part of what employers seek to do with the arbitration system is sweep problems under the rug. Now, obviously, some of the cases are defeated. Employers shouldn't be worried about those cases being public where they've been found not to have committed any wrongdoing. But in many of these cases, there has been wrongdoing. And by allowing it to be in a black box, it removes some of the incentive for employers to comply with the law. So I think that's an important area, is to require these providers to publish information and the awards themselves, to allow participants to better select arbitrators, weed out ones that are showing patterns of bias. I think that I'd comment on a couple of other things we heard. As Mr. Steck said, I too have not seen one of these opt-out arbitration clauses that allow employees the choice to sign out of it. I don't doubt that they exist, but they seem to be exceedingly rare. I've never even heard of them, quite honestly. And a couple of my colleagues from Neal are here as well, and they haven't either. One other big area I think that needs to be addressed, which hasn't received a ton of attention today, are the costs and fees of arbitration. It can be very expensive, even for higher level employees who are making six-figure salaries and bonuses and whatnot, to pay an arbitrator several $100s an hour on top of whatever filing fees the providers charge, can really be a huge disincentive to bringing a claim, or put a lot of pressure on a claimant to settle a claim on the cheap that may be, a completely valid claim, because they can't afford to pay thousands of dollars for an arbitration. And there is no, currently no regulation of that in New York. There have been some court decisions in statutory employment discrimination claims, like Title VII claims, saying that in very rare circumstances, a claimant who can't afford the fees of an arbitration provider might be able to get out of that. But I think that's an area that would be outside FAA preemption that the New York legislature could mandate arbitration providers to allow procedures for claimants who can't afford the fees to have relief from that. And we heard from the prior witness that many employers, or I guess the claim was most employers, have employers pays clauses, and those certainly do exist. But again, I've been doing this 20 years, and maybe it's higher level employees, but I see those very rarely. Most of what I see are 50-50 clauses. Each side pays half. And obviously that's a much greater burden on an individual employee than it is on a corporation. So having some regulation in that area, I think would be appropriate. A couple of other concepts that I thought were worth touching on, or suggestions, and they may not be earth-changing, but I think they could be significant in areas in the narrow scope of what the state has been left to do outside of the FAA that could be useful to improve the process. One is statutes of limitation. This is something that's been a bit under the radar screen, but I think has been on the rise, where companies in employment contracts will say, you've got to bring your claim in 6 months or you lose it, or you have to bring your claim in 1 year or you lose it, even though a breach of contract statute of limitations in New York is 6 years, for example. A defamation claim, for example, might be 1 year. A tort claim might be 3 years. If the legislation is done in a way that's applicable to all contracts, I think it would be outside of FAA preemption, because sometimes these contractual statute of limitations are done in employment contracts that don't even have arbitration clauses as well. So it's certainly something that could be addressed, and it's I guess ostensibly the claim by employers would be, we want to expedite the process and not have a resolution 6 years later when memories have faded and whatnot, and there's probably some merit to that, but I think it's fairly obvious there's also a bit of a gotcha agenda to get people to have their claims expire before they have time to find a lawyer and recover from getting fired and find another job. Often people have priorities that they have to deal with before addressing potentially bringing a lawsuit. I think that the one other thing I would mention, and we've heard a little bit about this, is the notion that arbitration, I addressed the point that it's an even playing field, which I don't think it is, but the idea that it's quick, efficient, and less expensive, I think, is becoming less and less tenable as well. I addressed the expenses, but I can say from personal experience, I've had employment arbitrations, one that lasted 36 days, one that lasted 54 days, and one that lasted 75 days. And they're not done straight through. So these took 2+ years to finish. Now, I'm not going to say that that's typical, but it's not that unusual. For whatever reason, arbitrators often are much less willing than judges to really control the process, so it can become not only more expensive for a claimant, but much more time-consuming. And I think what has started to happen is that the defense bar has been trying to sort of get the best of both worlds. It used to be that arbitration, yes, it was sort of quicker for both sides. Now what's been a trend is that employers have pushed, and arbitration providers often are providing the ability for motion practice. One of the benefits of arbitration used to be there wasn't a lot of motion practice, and at least as a claimant, you pretty much had the guarantee of getting a trial, which was some benefit of the process. Now, providers are often allowing for summary judgment motions, which are often unfair because you don't have the full scope of depositions typically. Maybe the arbitrator will provide for depositions, maybe they won't. Sometimes the arbitration clause will allow for depositions, sometimes it won't. But a lot of times what'll happen, for example, is each side maybe gets one deposition at best. And that is a lopsided, it sounds even, but it's really a lopsided situation because it's usually the claimant that would need to take multiple depositions of multiple decision makers at a company who are involved in a termination decision, for example. And the company usually just wants one deposition, which is the claimant's. So they're getting everything they want, and the claimant isn't. So you have a lopsided discovery process there, and then to also allow for summary judgment motions really isn't fair. You know, I suppose that could be an area the legislature could consider for regulation. I'm not sure whether, you know, the federal courts would consider that to be, you know, overstepping the bounds under the FAA. But that's it for my testimony. I'm happy to address any questions.
Thank you. We've been joined by Assemblywoman Arabella Simotis, who's a member of both of our committees. Do you have any questions first?